Attorney General Sessions, has the President ever expressed his frustration to you regarding your decision to recuse yourself?
Senator Heinrich, I'm not able to share with this committee private communications.
Because you're invoking executive privilege.
I'm not able to invoke executive privilege. That's the President's prerogative.
Well, my understanding is that you took an oath, you raised your right hand here today, and you said that you would solemnly swear to tell the truth, the whole truth, and nothing but the truth. And now you're not answering questions. You're impeding this investigation. So my understanding of the legal standard is that you either answer the question, that's the best outcome. You say, this is classified, can't answer it here. I'll answer it in closed session. That's bucket number 2. Bucket number 3 is to say, I'm invoking executive privilege. There is no appropriateness bucket. It is not a legal standard. Can you tell me what are these long-standing DOJ rules that protect conversations made in the executive without invoking executive privilege?
Senator, I'm protecting the President's constitutional right by not giving it away before he has a chance to review it. And secondly, I am telling the truth in answering your question in saying it's a long-standing policy of the Department of Justice.
Are those policies written?
Even and to make sure the President has full opportunity to decide these issues.
Can you share those policies with us? Are they written down at the Department of Justice?
I believe they are.
This is the appropriateness legal standard for not answering congressional inquiries.
It's my judgment that it would be inappropriate for me to answer and reveal private conversations with the President when he has not had a full opportunity to review the questions and to make a decision on whether or not to approve such an answer. One, there are also other privileges that could be invoked. One of the things deals with the investigation of the special counsel.
We're not asking questions about that investigation. If I wanted to ask questions about that investigation, I'd ask those of Rod Rosenstein. I'm asking about your personal knowledge from this committee, which has a constitutional obligation to get to the bottom of this. There are 2 investigations here. There is a special counsel investigation. There is also a congressional investigation. And you are obstructing that congressional investigation by not answering these questions. And I think your silence, like the silence of Director Coates, like the silence of Admiral Rogers, speaks volumes.
I would say that I have consulted with senior career attorneys in the department.
I suspect
and they believe
you have.
This is consistent with my duties.
Senator Risch asked you a question about appropriateness. If you had known that there had been anything untoward with regard to Russia and the campaign, would you have headed for the exits? Your response was maybe. Why wasn't it a simple yes?
Well, there was a improper, illegal relationship in an effort to impede or influence this campaign, I absolutely would have departed.
I think that's a good answer. I'm not sure why it wasn't the answer in the first place. I find it strange that neither you nor Deputy Attorney General Rod Rosenstein brought up performance issues with Director Comey. And in fact, Deputy FBI Director McCabe has directly refuted any assertion that there were performance issues. This is troubling because it appears that the President decided to fire Director Comey because he was pursuing the Russia investigation and had asked you to come up with an excuse. When your assessment of Director Comey didn't hold up to public scrutiny, the President finally admitted that he had fired Director Comey because he was pursuing the Russia investigation, i.e. the Lester Holt interview. You've claimed that you did not break recusal when participating in Director Comey's firing, but it appears that his firing was directly related to Russia, not departmental mismanagement. How do you square those 2 things?
Well, you had a lot in that question. Let me say first, within a week or so, I believe May 3rd, Director Comey testified that he believed the handling of the Clinton declination was proper and appropriate, and he would do it again. I know that was a great concern to both of us because it did not, that represented something that I think most professionals in the Department of Justice would totally agree, that the FBI investigative agency does not decide whether to prosecute or decline criminal cases. Pretty breathtaking usurpation of the responsibility of the Attorney General. So that's how we felt. That was sort of additional concern that we had heading the FBI, someone who boldly asserted the right to continue to make such decisions. That was one of the things we discussed. That was in the memorandum, I believe, and it was also an important factor for us.
Before I recognize Senator Blunt, I would like the record to show that last night Admiral Rogers spent almost 2 hours in closed session with almost the full committee, fulfilling his commitment to us in the hearing that in closed session he would answer the question, and I think it was thoroughly answered, and all members were given an opportunity to ask questions. I just want the record to show that with what Senator Heinrich stated. Senator Blunt.